do I understand correctly, intermixing Delaware and the Cherokee are pretty much indistinguishable as far as
from our perspective,
from a membership standpoint?
Well, if you go back historically, you're looking at our predecessors. You would go Delaware, Raritan, Wenami. It just the name changes depending upon what historian's looking at them at what period. You go back all the way to when the Dutch were here under Kieft, were referred to as the Raritan or the Unami. More current would be Delaware. And during the Cherokee migration of 1711, some Cherokees came up as they were passing through, and they asked if they could stay. And those Cherokees intermarried with Delaware. So we are a Delaware tribe, a Lenape tribe with Cherokee members.
The Lenape are really I always thought the Lenape were a synonym for Delaware.
Delaware are Lenape, but I mean, when you look at Lenape, you have an Algonquin-speaking group of people. So we have Lenapes that are up in New York.
Right.
You know, Iroquois are cousins. So it's a larger ethnic group.
Lenape is a relative term, essentially?
It refers to oldest people. We're referred to as the grandfathers. So it designates them more or less an Algonquin-speaking group of people.
Well, that helps. Thank you.
No, not a problem.
I guess over the years it does get a little
well, there's a lot
mixed.
of tribes, and then as they begin getting recognition, everybody wants to differentiate themselves.
Yeah, the heart and soul of this lawsuit, as I understand it, basically boils down to the fact that the state of New Jersey really fails to recognize your particular tribe.
Well, it's really a little bit more than that. If you go all the way back to 1758 to present, the state of New Jersey has deliberately ignored every federal law and treaty in relationship to Native Americans, American Indians. They've broken every treaty. They've broken the Treaty of Easton. They've broken the Jay Treaty. They've broken the Ghent Treaty. They've violated the Trade and Intercourse Act of 1790, 1793. They violated the American Indian Citizenship Act of 24, the Civil Rights Act of 64, the Ku Klux Klan Act of 1871. I mean, it's a plethora. This is just the complaint. The brief itself is almost 100 pages.
But there is some recognition by the state of certain tribes, are there not, that are in effect related to the Sand Hill branch?
In the state of New Jersey, the other tribes, I refer to them as Indian entities, that sit on the Indian Commission in Trenton are actually 501c3 nonprofits. And the reason I know this is our previous chief, my first cousin, even created their name for them when he was the only funding agency in the state. So he created the Nanticoke-Lenni Lenape, but their business structure. Unfortunately, the courts have just ruled. Like me wait for that to pass. Unfortunately for some of the Ramapo over at Mawa, they had to go to court to remove their chief, and the courts ruled that actually they're a business structure, so they don't have a chief. He's a CEO of a nonprofit. So I refer to them as Indian entities. While they are American Indians, they are not an American Indian tribe.
They're not recognized as a tribal entity by the state, only as a business entity, is what you're saying?
Yes, and that is their structure. They have a corporate structure.
Okay.
We are a tribe. We are indigenous to the state, and we've been here for thousands of years. 18 months ago, Dr. Stefano at the Patterson Museum returned 1,800-year-old bones to us that were a direct link to my first cousin's DNA, and we repatriated them. My family's been here for thousands of years. We have a traditional tribal structure, and when the state of New Jersey created the Indian Commission, they neglected to fold the Sandhill into it. Prior to the year 2000, if you look at any publication that talks about Indian commissions, the New Jersey Indian Office was always spoken of as the Indian Commission. That has traditionally been chaired by the chief of Sandhill because we were the only tribe in the state. All indigenous people, including the Delaware and Oklahoma, recognize us as the indigenous people that belong in the state. Unfortunately, the state of New Jersey has refused to have any dialogue whatsoever.
And that is what this lawsuit seeks, is dialogue, recognition, and some reparations.
It's beyond reparation. If you take a look at the ratification of the Constitution for the state of New Jersey, August 13th, 1844, that's when it was ratified. That's when the state became a state.
Not to be argumentative, but wouldn't the state have become a state when it was accepted into the Union back in the late 18th century?
Their constitution would have had to have been signed for them to be a state.
But they were recognized, the federal government recognized it as a state. They had voting rights in Washington as a state.
Federal government recognizes us as a tribe, but we don't have supervised status. So there's a legal differentiation there. But as far as ratification, in order for the state to be a state, their constitution has to be ratified by the people, because that's the governing charter. Just like the Constitution of the United States had to be ratified. It's the supreme law of the land. Each state has its own constitution. New Jersey's wasn't ratified by the people until 1844. As a result of that, everything that the state did in an official capacity is moot and null and void prior to that date, including their dealings with us. They didn't have the legal standing to be able to enter into an agreement, let alone take the land back in violation of all these other federal laws which were already on the book.
That being said, if the courts were to go along with that reasoning, then what are you seeking from the courts as far as relief is concerned?
We are requesting of the courts all of our traditional lands, the acknowledgement and restoration of our water rights, which extend to the lakes, rivers, streams, as well as all the aquifers underneath of Wharton State Forest. Our traditional fishing, which goes from the bay that separates New Jersey and Delaware and extends from the low water mark up the coast to the mouth of the Raritan and 2.5 miles out. That's traditional Indian title. We are requesting of the courts that the state be given a restraining order from charging our people tolls on the bridges, registration on automobiles, any type of taxing whatsoever, because that's illegal according to the treaties that are still in effect. Basically the restoration of who we are, the acknowledgement of our culture, and being put back in our original status that we enjoyed prior to the United States and with the Commission of the United States. Originally, we have treaties with the British Crown, and they're similar in size and scope to all the treaties you find from Maine down through New York, because it's one of those first colonization periods. The treaties after the United States is established going west are different. The British Crown dealt with us as sovereign. Because of their right of discovery, they had to deal with us on a king-to-king basis. When the United States was formed, those treaties and land grants, if you would, were grandfathered in. And then with the establishment of the Trade and Intercourse Act of 1790, the United States codified the fact that only the Congress and the President of the United States could deal directly with the Indians on all matters relating to real property. In 1802, the state of New Jersey passed a law, which is kind of tricky because they weren't really a state because their constitution wasn't ratified, saying that they could sell our land in violation of the Trade and Intercourse Act of 1790.
So you have two violations there. One, the constitutional issue, and the second one, they were in violation of federal law.
Yes, and they were in violation of many more, which is in the brief we can provide for you.
So you're seeking, in addition to the water rights and exemptions, you're also seeking
hunting and fishing,
land, in effect, land grants or land restoration around the Wharton State Forest
water
area?
Yes.
Okay.
When you take a look at the Winters water right cases that the Supreme Court ruled on, it's inherent. Any land that's reserved by the federal government for whatever the purpose, as long as it's reserved by the federal government, it is understood that the water rights are reserved with it. That's a fundamental legal tenet. It's non-disputable.
The $1 trillion figure is based on?
Well,